Thanks. Good afternoon, everyone. My name is Celia Blake. I'm the Deputy Dean for Graduate Studies and Research here at Mona Law, and I extend to you a very warm welcome to yet another in Mona Law's Masterclass series. Our masterclasses are public-facing events in which we aim to pull you into the Mona Law teaching and learning experience, and we hope to whet your appetite to engage in our programs. But these classes also provide us with an opportunity to share our teaching platform with thinkers from outside the faculty who can bring value and additional perspectives to our classroom on various dimensions of the law. I know our audience here today spans the entire Caribbean. We have had respondents from 19 Caribbean territories, in addition to jurisdictions beyond the Caribbean region. So I'm happy to see the interest from across the globe. Just by way of information, and as some of you may already know, this is the 6th class in our masterclass series, which we started somewhere back in 2019. Our most recent masterclass was one in August in procurement law. We've also had masterclasses in insolvency, in company and corporate governance, in human rights, and today's masterclass will merge public and private law in what I think promises to be a thought-provoking presentation from Justice Peter Jamidar of the Caribbean Court of Justice. I want to especially welcome some of our guests here in the Zoom room. Mr. Peter Golson of the firm Miles Fletcher and Gordon here in Jamaica. There's also some of our colleagues who have been involved in the University Rights Advocacy Program, URAP, some of whom have taken judicial appointments. Dr. Justice Arif Balkan, welcome Arif, of the Court of Appeal of Belize. I see too Justice Westman James of the Barbados High Court. Also of URAP, Mr. Douglas Mendez, SC, welcome Douglas. We also have Ms. Gabrielle Elliott Williams, lecturer, right here at Mona Law, but she is away in colder climes at the moment. Glad to see you, Gabrielle. Again, a very warm welcome to you all. And so I am going to invite you to pin your ears back and be attentive in this class. I think we are in for quite an intellectual treat. And at this point, I'm really going to just turn you over to our moderator for this afternoon's class, Mrs. Suzanne Foss-Golson, our corporate governance specialist here and senior lecturer in the Faculty of Law. Suzanne, over to you.
Thank you, Celia, our esteemed Deputy Dean for Graduate Studies and Research, who has been a great support. And I just wanted to also add my welcome to all of you who have joined us this afternoon, and of course, those of us in the Zoom room, and of course, a special welcome to Justice Jamidar, our presenter for the masterclass. It is really a special honor to have you, Justice Jamidar. And I also wanted to, for us to note that I am not the only one moderating this afternoon. My co-moderator is Professor Tracy Robinson, our esteemed also public law expert, one of the foremost public law experts in the Commonwealth Caribbean, and of course, the co-author of Fundamentals of Caribbean Constitutional Law. And I am very happy to be joined by Tracy this afternoon because we can now balance the scales with the private and the public law. Without much delay, I don't know if Tracy wished to say a few words, but welcome again, and I'm seeing other familiar faces, so I'm very excited for what we have in store. And as Celia said, an intellectual treat, so we look forward to the discussion.
No, Suzanne, I wanted to join in welcoming everyone. You know, we have a few people in the Zoom room, but many more who have joined us on YouTube. And we have really enjoyed hearing where persons are from, knowing who is with us from around the Caribbean. We've had many activities, and the University of the West Indies on all of its campuses have. But it's great when you have registrants from every single English-speaking Caribbean country, and Suriname, part of the CARICOM region. So I'm keen to hear where folks are from on YouTube, and we're using the Mentimeter platform today. So you'll see a link in the chat on YouTube, and would love if you simply just let us know where you're from. We'd actually love if you can tell us who you are as well. If you are comfortable on YouTube sharing that with us. So I hear someone from San Diego de la Vega. Now that's a code to for Jamaican, for those who did not know. So this is someone in St. Catherine, Spanish Town. Excellent. Are there folks from anywhere else? Have you had a chance, hopefully, to connect to the Mentimeter platform if you haven't used it before? And welcoming others to the room, welcoming on the inner room, Zoom room, Justice Maynard Phillips, who is joining us both from Jamaica and the Belize Court of Appeal. So it can't be that we only have Jamaicans here. So I'm seeing online that we also have from St. Vincent colleagues. We have from Antigua, from Nevis. We have colleagues, of course, from Trinidad and Tobago, from Grenada, from Guyana. We have from all over the Caribbean colleagues, and welcome to you who are joining us on YouTube as well. We're excited to have you. Get familiar with Mentimeter so that you can participate and connect with us online as you are also on the YouTube platform. And keep on telling us. I see the Chief Justice of the Bahamas is here with us. Welcome, Chief Justice. And I'm seeing colleagues teaching on different campuses of the University of the West Indies, Faculty of Law, but also lawyers from right around the Caribbean, from the north and west all the way to the east and the south. Welcome, everyone. Welcome, everyone. And also we're beginning to hear who some of you are. And so please feel free to continue to tell us where you're coming from and how you're participating with us, not only from the Caribbean, but we know from further afield. Back to you, Suzanne.
Oh, thanks, Tracy. And I just wanted to do a quick shout out, if you will, to my corporate governance class. That is also a reflection of the wider Caribbean. So feel free to also punch that in the Mentimeter and to let us know, because I'm not the only one here, I know you, but the rest of us know that not only where you're coming from, but if you're a part of the class. So without much delay, most of us are aware that there has been a lot of movement in the corporate governance space relating to issues such as human rights, issues relating to the environment, and they're not necessarily mutually exclusive, and the emergence of ESG. And what is interesting about today is that we will get some insight as to how public law has impacted, interfaced with, interlocks with the private law sphere. So much of the work that I have done is in the private law sphere, Tracy public law sphere. And it is very fascinating for me personally, I'm sure for all of us, to see how public law is influencing corporate law and the behavior of corporations. So before I go on and on, I'd like to hand this over to Justice Jamadar to carry us on this journey. We look forward to it, Justice Jamadar, and welcome again.
And Justice Jamadar needs no introduction.
That's correct. I wanted to read the bio, but here we are.
Yeah, thank you, Suzanne, Tracy, Celia, and welcome to everybody who's joined this this masterclass. As you see on your screens, the topic is We the People, Exploring Private Power, Public Law Principles, and Good Governance. And I mean, as Suzanne said, this is really her corporate law class. And so the obvious question is, why are we talking about public law in a private corporate law class? Well, why should we be talking about that? Well, maybe just as an easy entry point, you know, public law is really all about, you think government, but actually it's about good governance. And good government is about good governance. And what's been happening, not recently necessarily, but what's certainly been happening in our region a little more recently, is the intersection between public law principles of governance and good governance, we hope, and private corporations, private entities, including individuals. So for those of you who are here from the private law world, and for those of you who have kind of checked in because you're in the class and you have to turn up to get your credits, and you're asking yourselves, well, you know, how is this class going to be relevant to me as a private law lawyer? As we start, I want to say to you as a group that public law principles of governance are increasingly intersecting in the private law realms. And this exploration, and I must say it's limited, we have limited time and there's a lot that's going on. Even though it's limited, I think it's going to help you potentially navigate in some practical ways these private public law issues, these intersections that corporations are facing, I think will face, and that our societies have to face. So if we move along to the next slide, where do we start? Where do we start this conversation? And I want to place this conversation in the context of values. Values founded upon identity, and identity shaped by ideals. Where do we start? We start by asking a fundamental question. What does it mean to be a Caribbean democracy? Why is this important? It is important because, as we will see, all of what we do, all of who we are in a legal construct comes fundamentally out of what we call constitution, constitutionality, constitutionalism. And that's where, from my perspective, I think it's important that we start asking and answering the question, who are we and what are our ideals? Who are we as state and as state actors? Let us be very clear about something. In this modern era, the corporate private entity, including individual private citizens, are significant actors in societies, in the region, and in a global world. Way back in 1985, a judge from Trinidad, he's there up on the screen, Justice Lennox Dial Singh. He's actually still alive in his 90s. I think he's celebrated his 95th or 96th birthday recently. Had this to say in what some people consider to be a seminal decision in public law, case of Rambachan versus TTT. We will look at it a little bit later. For it is in the area of the Constitution and constitutional law that the heart of a country is opened and its sense of right and justice breaks forth. I start there because as we proceed on this little journey together this afternoon, I'm hoping that you will see and share how, well, first why, when, and how this idea of constitutionalism is integral to good governance in corporations, but also in all of private law relations and for our society. When we talk about governance, I want you to also put aside everything that you have in the past imagined it to be. Because for quite often we come to governance in a kind of hierarchical, top-down approach. And I want you to just have an open mind and start thinking about governance in this sense. To think about it as the behaviors of persons and groups that may be influenced by the activities of others. That's all. It's about how behaviors are influenced and influenced by others. If we frame it that way, then right away we can begin to see from a corporate law point of view that the activities of corporations or of individuals have a significant impact and influence on actions and behaviors of others. Marketing is an easy example. We're all buying stuff online. And we all know that if you buy something, all of a sudden what pops up next when you go back onto your phone or your laptop or your iPad or whatever it is, options that resemble your earlier activities, whatever they may be, AI in action. But it demonstrates the reach of corporations in our world. Can this reach be separated from values? And can this reach be separated from values that are anchored in what de Alsing says is at the heart of what is justice and what is right? I'm going to go very quickly through some general principles and then come to what I think we really want to hear about. But I think this is ground that we need to cover. So we'll just move along to the next slide. A plan for a way of life. In a sense, I've covered that. But Professor Simeon McIntosh makes the point. He talks about constitution as virtually the whole of what is sometimes called the form of life of a human community, describing what life should be like. I think it's a good starting point because it's inclusive. Corporations are not apart from this. No one is apart from this. Indeed, we are all a part of this. And so once you begin to see constitution through this lens, you begin to see its inclusive nature. What we have to explore is what is its reach. Next slide. Still moving along, it is a principal expression of a higher law, of the political ideal of a people to govern themselves, itself in a certain way. Notice governance is therefore the heart of constitutionalism. Why a constitution? What is its function? Its function is quintessentially governance. Governance in an agreed way, in a way that has been negotiated, but based on values, as we will see in a moment, as we move along. To the next slide. I want to invite you right away to get involved. Suzanne and Tracy and Celia have said that we want your input. So there's a question up. You're on your Mentimeters. While I chat a little bit about it, you can start answering. Do you agree that a constitution describes and prescribes, here is what's the key, the core values that a society, an entire society, including corporate constituents, that a society agrees to govern itself by? You have 4 choices. And so let's take a moment and start responding to the question. I know it takes a moment to load, and so there's a little lag, but the question is, do you agree that a constitution describes and prescribes the core values that a society agrees to govern itself by? Notice the emphasis on governance. Your choices are, I agree, I mostly disagree, I disagree.
Yes, we're beginning to get some feedback, Justice Jamadar.
So Tracy, are we going to have this conversation? Are you going to call me Peter, or are you going to call me Justice Jamadar? If you have to call me something, please just call me Judge. We could leave the Justice Jamadar off. I'm going to call you Tracy, and this is a meeting of, as we chatted, a meeting of equals as far as I'm concerned. So yeah, sorry, Tracy.
No, so I'm noticing that mostly agree. And so there are more mostly agrees than agreeing. And that may mean that folks think that they are other spaces which describe those values, or the Constitution doesn't. You know, for example, the Jamaica Constitution has no preamble. So it'd be hard in Jamaica to have a very strong sense of those values. But it's good to see the feedback. No one disagrees. Have you noticed that?
I think that's important. I think what we see is no one disagrees. And if you put a cumulative of mostly agree and agree, we're kind of getting to 20 versus 3, which I would say is a significant number of persons who are suggesting that even in a corporate world, even in a private world, that core values, constitutional core values, describe the way in which a society agrees to govern itself. So I don't know how long you want to give it, Tracy, if you want to give everybody an opportunity. I mean, you know, but it's up to you. You decide when we come out of this and move on. I would leave it to you, Suzanne and Celia.
Yes, yeah. Suzanne, what do you think? I think we have a pretty good sense.
We've got a pretty good sense. I am tempted to say that I was going with the majority.
Succumb with the temptation, Suzanne. What are you thinking? What would your vote be? What would your vote be?
So, George, it's I mostly agree because of the I think as we go along, it will become clear as we discuss why so many mostly agree as opposed to just outright agreeing.
Yeah. So, okay, so if we're going to close off now, just for everybody, we have 10 agreeing, 11 agree. Oops, yep. So there's a little competition going on here. This looks maybe, well, not quite World Cup football, a lot too many goals, but still, we have 11 agreeing, 16 mostly agreeing, 3 I mostly disagree, and 1 I disagree. Now, just to be very clear, all views and perspectives are valued. Every perspective has an element of salience and value for the conversation. So I don't want those who may find themselves, oops, I'm in the mostly disagree minority. So-called minority voices are very important in the conversation. Why? Because actually they help us shape how we move forward in a democratic society. So just to be very clear about that, all positions are welcomed and valued. Well, let's move along then. I think that's the consensus. Let's move along then to taking a step closer to what we're here about. And I just want to use this as a framer. And some of you may know, some of you may not know, but in 2011, the United Nations Office of the High Commissioner of Human Rights, considered the, if not one of the leading UN agencies for the promotion and protection of human rights, published guiding principles on business and human rights. And the objective of the document is to enhance standards and practices with regards to businesses and human rights. But look at this. There's something very practical about the outcome, so as to achieve tangible results for affected individuals and communities. So there are two sides to it. Here's the UN saying, listen, 2011, for whatever reasons, we think we need to have this conversation of the intersection of human rights and companies, businesses, and we think it's important enough to sit down, do some brainstorming, bring in our experts, advisors, have these sessions, and come up with guidelines, which they did. And they are in service of tangible results for affected persons. So they're very practical in that sense. The next slide. In those guidelines, there are 3 things. The first and the third, I think, are going to be not very controversial. The first is that states must respect, protect, and fulfill human rights and fundamental freedoms. Nobody in this session, I hope, is going to dispute that. That's the responsibility of states, especially like Caribbean states where we have a written constitution. And then 3, of course, if you are protecting rights, but then you must have remedies. You must have recourse, and then remedies. So if appropriate and effective remedies when there are breaches. A little nuance on that we can talk about. The state's obligation not just to wait to solve problems and address breaches, but to promote rights. But look at what the second one is. It recognizes the role of business enterprises as specialized organs of society performing specialized functions. and how they are required to comply with all applicable laws and to respect human rights. Question that we're going to move into is, if corporations are required to comply with all applicable laws, what does that mean? Is that limited just to the laws, your company's ordinances, your company's acts, rules and regulations? Is the Constitution an applicable law? Is it? That's part of what this little exploration this afternoon is about. So let's just move along. I want to go very quickly over something just to set a context. It's an area that I am in a way sort of hijacking for this session, but it's relevant. But it's something that I'm very, very concerned about. And I spend a lot of time, my professional time, regionally and internationally speaking about this. And that is the problem of human trafficking, modern forms of slavery, forced labor, domestic servitude, especially among women, children, vulnerable groups, including sexual exploitation. September 2011, the ILO publishes its global estimates of forced labor and forced marriage. And it's significant in this corporate business law class because of what I'm going to share. 27.6 million persons are in positions of forced labor. Now, some of you may know this, for some of you, you may not, and I hope it surprises you, and I hope it disturbs you. Women and girls make up 11.8 million of the total number of persons in forced labor, with 3.3 million being children. Just think about that for a moment. So there is a gender discrimination perspective to this phenomenon and to what we're going to talk about a little bit today. In the last 5 years, the numbers have increased by 10 million in the Americas. We are located geographically in that area we call the Americas, is a significant area of occurrence. Next slide, please. The increase in the number of persons in forced labor was driven entirely by forced labor in the private economy. So private lawyers, your question is, what's the relevance of what we're going to talk about? Well, here, in this question of forced labor, it is driven by your constituents. 86% of the forced labor cases are imposed by private actors, not just corporations, individuals, domestic servitude, farms. We'll come look at a case from the Supreme Court of Canada, Fraser, a little later on as we go along, and we're going to see what this is all about. The Director General of the ILO in September 2022, that's just a few months ago, says nothing can justify the persistence of this fundamental abuse of human rights. Is this a concern for you in the corporate world? Is this an issue that the private law world and realm has to take cognizance of? Next slide, please. To be clear, because we're talking about intersections between private law and public law, in the Caribbean constitutions, there are some jurisdictions have clear prohibition. No person shall be held in slavery or servitude. No person shall be required to perform forced labor. Very, very explicit. But of course, we have those more indirect prohibitions: inhumane, degrading punishment, torture, protection of personal privacy, personal dignity, freedom of movement, obviously, and the right to liberty. So immediately you can begin to see there is a phenomenon that is arising. If the majority of forced labor cases in the Americas are being sponsored and committed by private entities, and if our constitutional framework prohibits them based on human rights as human rights violations, the obvious question that we need to be asking is there an intersection between the two? Now, I know you're going to tell me, well, okay, every jurisdiction has TIPS legislation, that is trafficking in persons legislation. And so there is a law to deal with it. Well, that may be so, but I don't want us to get caught up with the TIPS legislation. I want us to stay centered on what do we do when there is an intersection in the private corporate world and constitutional values. Now, human trafficking is not something that is to be disregarded. There are established local, regional, international cartels, corporations that conduct their business in forced labor. Yeah, that recruit and exploit? What is the reach of the values that the majority of you said should be shaping how we govern ourselves? Should they be influencing the private law realm? And if so, how? For judicial officers, those of you who are present, what is our role and responsibility in this regard? And of course, I'm using this as an entry point. This is not about forced labor. It's about an example of a fundamental right. What about the right to non-discrimination? Surely that is no less important in employment circles and the private law spheres. Where is the intersection between constitutional values, standards, because every value sets a standard, and private law? Let me move along. I need to go a little quickly, that's fine. Authorship and responsibility, this is just simply saying that Simeon McIntosh says we are the authors of our fundamental law. And so I'm just trying to locate it in the sense that the Constitution is not something outside of us. It's we the people who have brought it into being. Next slide, please. Let's shift to a question to get you engaged. The question is, do you think that the law should provide constitutional redress as between private citizens and private corporate entities if the latter, private corporate entities, are engaged in practices of forced labor? Do you think the law should provide constitutional redress? Now, I want you to answer this question not with your legal hat on. You know, we're all lawyers, and you're going to cut and pass and start thinking about all the legal questions. I want you to just put that aside for a little while now, and especially Tracy, because Tracy is going to give us all of the legal responses, all perfectly correct answers. And Suzanne also. What do you think as a citizen of this region? Do you think that the law should provide constitutional redress? Constitutional redress in the sense of valuing of values. So let's just share your thoughts. There's a simple choice, yes or no.
So Judge, you know, folks can go back on Mentimeter.
Yeah.
So I see that some are unable to connect to the Mentimeter for this one. So we may have to jump to the next one.
That's okay, that's fine.
It doesn't work. Judge, you have a Phantom Creek that we're here.
No, the Phantom Creek is my old chair.
Ah.
So think of it as something that adds a little bit of texture to our session, a little bit of character.
Yes, yes. I know others may be wondering, and we thought we were pontificating. So this one may not work.
All right, that's okay.
The next one. So this one is really asking, do you think you should be able to get constitutional redress in respect of matters involving private corporate entities and what they do? But we do have another question. Which
in a way is what this question invites us into. So it's actually perfectly fine if we come to the second one and let's deal with that one. Okay.
Hopefully this one comes up.
Yeah, let's see.
Let us know if this one works on Mentimeter.
Except that, Tracy, George, we are seeing a number of yeses, and I'm assuming that that was for the one before, and this is on YouTube.
Yes, you're correct.
So I'm getting some yes.
Okay, good.
I don't know if it's a good sample, because it's about, more people are saying yes. I don't know to which of the questions.
Well, it would have been to the first question, right, but you've just posted
there the second. There's a delay.
Yes.
And of course, this is beautiful because now we're getting a graph. Excellent.
Yeah. Okay, good.
Yes. And I also hear Douglas Mendez in the room asking, why constitutional redress? Why not simply a legislative response?
Great. And so that's where Douglas, great question, of course. Not surprised that you would come to that so quickly. And the second question is really inviting us to kind of look at that. Yeah. Because
Yes.
the second question, well, we just give the first question. Remember, Douglas, for now, the first question is not to be too legalistic. It's just kind of this sense of feel. Do we feel that these values are so important that, listen to me, if this is happening in the private world, these values matter. There should be an intervention. That's what I want from the first question. When we come to the second question, which I think we'll put up, oh, there we go. So the second question is up now. Do you think the state includes, of course, the executive arm, legislative arm, judicial arm, Douglas, legislative arm. Do you think that the law should provide constitutional redress between private citizens and the state if the state fails to exercise due diligence to prevent private corporate entities within the state from engaging in practices of forced labor? So now here is, the question is a little different now. It's a little bit of a nuance. Sorry, Tracy.
Can I come back, Judge, to some of the earlier interventions?
Sure.
On YouTube, Renee disagrees on the first question, and she really wants to know whether this isn't overreach.
Exactly.
Into the private sphere. And we also had from Angelina concern about the massive monopolies like Google and Meta, and whether there isn't a need for our values to be applicable to them.
And that's the balance. And we think about these big international like Google and so on, but in the region, let's understand something. In the region, we have conglomerates that are creating monopolies, right? And with these monopolies, you have questions of labor, of exploitation, and so on. We're going to look at a case from the CCJ, Sandy Lane, a little later on, and have a little look at that. But I think these two things that you've pulled out, Tracy, actually show what's in the balance. And the question was intended to provoke that balance. What is overreach and what is required? Yeah, and this area is at that intersection. Regrettably, we may have no neat, easy answers for those of you who are lawyers or law students and want a yes-no solution. This is one of these areas where we have to get down and get messy as we work it out. So Susanna, Tracy, you want to comment on the second question? I think we have, this is sort of where Douglas, I think, was taking us, yeah?
Well, there seems to be an overwhelming yes when it comes to the state and private entities, and that's interesting again. I don't know, it would be interesting to hear Renee on that one as well. How far is too far, and is it now time for there to be that
but what's interesting for me is this is a sort of a locus standi issue, right? That a private citizen can, we are saying 22-2, can maybe come to the courts, for example, and say to the state, listen to me, you have failed in not, Douglas, legislating or regulating or whatever it is, monitoring what's happening. And that's a sort of a segue between the two extremes, right? The state's responsibility in relation to these values, but how private citizens can intervene and try to leverage action to protect the values. Remember what we're talking about here, I'm trying to suggest at the core is values that we all say are fundamental and important to the kind of society we want to have. And we're trying to say it's inclusive, nobody's excluded. The corporate world is a part of our world. Are we good with this? And you want to move along, Tracy?
One more comment, Judge.
Yes, Suzanne, sure.
Cindy Herbert makes an interesting point, and she's looking at it from, I think, a practical point of view. And she says the state needs to have the resources and manpower to exercise due diligence. Not sure that is realistic, she says. And she who are we talking about?
So excellent. The resource issue, right? The resource issue, person power, resources, right? So who was the person who contributed? Just so I can remember the person's name.
Herbert.
Cindy, right? So Cindy, for me, if you don't mind, if I can call you Cindy, if you want to call me Peter in this call, that's good. It's equality of treatment, right? So I'm good with that. But are there some values that are so fundamental that the resource question cannot be an excuse? For example, torture. slavery. That's why I put it there as an entry point. Can the state say, we don't have the resources, so you know what? We can't intervene. We know there's human trafficking going on. We know women and children are being sexually exploited. We know all of that, but you know what? We don't have the resources, so we can't legislate for that, and we can't regulate it, and we can't put resources. It's a question for you to work out. It's a question for all of us to work out. It's a question that invites what is at the heart of democracy. It's a conversation that Tracy and I have been having, which is this. In the business of democratic governance, we hear about governance. Is governance singularly for the state in certain areas, singularly for corporations in certain domains, singularly for private people in another domain? Or is governance actually, and we talk about in our constitution something called about something that expression we use in many preambular clauses, participatory democracy. In Guyana, they're very strong about that, and Trinidad and Tobago, and in other jurisdictions. Is governance an activity in which all of the relevant state have a stake and a role to play in leveraging maybe the state to ensure that these core values are protected, whether it is legislating in relation to corporations or whether it is intervening, and is the resource explanation a way out? Pratt and Morgan in the Privy Council, many of our jurisdictions are still going to the Privy Council. Pratt and Morgan says when the explanation was given, well, we can't process these death penalty cases in under 10 years because we don't have resources. Pratt and Morgan, the Privy Council, said, well, hold on, that resource argument is not going to cut it. There's a value at stake here, which is everything that has to go with the death penalty. And therefore, delay is anathema. And the resource argument is not going to cut it. So I think it's a good question. And I think, you know, it's something that we'll work out as we go along. Tracy, we've spent some time on this. So are you? Yes, lots of doom and gloom. I was trying to read the last comment. Let's see.
Yes, that was a comment on the Twitter.
Oh, right. Yeah. It's a good comment because in the corporate world, if you disconnect from values, it's a question for our region. If we disconnect from core values, what is the consequence? What is the consequence? So that's why this session that Suzanne, that we're facilitating is so significant, because whatever our thoughts are, if you have unbridled license to corporations, for example, you've used the example of Twitter, somebody, and there are others, obviously, what is the effect on the values which we have negotiated and which we say are core and fundamental? Maybe we can move along, Tracy, so we could cover. We still haven't got to where we want to get to, and I know you want me to get there. So, yeah. All right. So we're going to quickly through these little bits here. These are just orient. Some of us are not as familiar with the public law realm, and I've been invited to just do a quick overview just to orient us, so that when we talk about courts and constitutionalism in the Caribbean, we're talking about basically, I'm suggesting, 4 main principles. Supremacy principle simply means the Constitution is supreme, and actually most of our constitutions say in a certain section, usually very early up, 1, 2, 3, 4, wherever it is, any law that is inconsistent with certain of these core constitutional principles, fundamental right, that law is void to the extent of the inconsistency. Supremacy is linked to sovereignty. So we establish ourselves in a constitution as a sovereign state, and the supremacy is linked to that. It must be drawn, a line must be drawn between a difference between a constitutional democracy, which we are in the Caribbean, and parliamentary sovereignty, which exists in the UK, where Parliament is supreme. So that's not our regime. So the supremacy principle is basically saying the Constitution is supreme. Right-centric principle says, and there's a lot of case law on this, obviously, that says, well, hold on a minute, fundamental rights are the heart of this business of creating a Caribbean democratic state. Indeed, there is an acceptance by the courts now that when we talk of rule of law, rule by law, that's a different conversation. Rule of law is now a values-laden construct. So it's not just formality, free and fair elections, rule by law, majority could do what they want. The Nazi regime, the apartheid regimes were all ruled by law, all constitutional. The rule of law says, now hold on, there's a value-laden content. There is a substantive aspect to rule of law, which includes at a minimum human rights, so that we take a right-centric approach. Supremacy principle, right-centric principle. The guardianship principle, this really falls for judges, judicial officers, I should say. And that idea is that, hold on a minute, who is responsible for protecting these rights? And the constitutions vest that, both that power and that responsibility with judicial officers. So for example, judicial officers through the process of judicial review, whether it is administrative or constitutional review, can strike down legislation passed by a parliament. So a democratically elected parliament passes a law and the constitution says judges can strike it down if it is inconsistent with certain core values, or as we say, not reasonably justifiable in a democratic society, their thresholds. But the point I'm trying to make is on the judicial overreach point, it's not that judges are sort of running off on their own saying yay or nay or in between. No, the Constitution creates this guardianship principle and vests that responsibility with the courts. The paramountcy principle, in a way, builds out of everything and out of the supremacy principle. And basically what it's saying is you must give paramountcy. What you must put, you know, like in family law, we talk about the welfare of the child is paramount. Well, core constitutional values, fundamental values are paramount. And this becomes important when we have to interpret, apply, make orders in court matters, but also when we have to pass laws, etc., etc. So in a nutshell, I think that those are the four core principles of Caribbean constitutionalism that I want to share with you. The next slide is, we go through these very, very quickly. Ishmael, I think you're going to just shift to right. Great. This is a case of the CCJ. Court would place a premium on affording the citizen his or her enjoyment of the fundamental rights. Now, notice it is not just restraining infringements, but a responsibility to afford them opportunity. That's actually in the CCJ decision in the Maya Alliance case. That's actually where we're going. So it's not just about restraining infringements, but it's also about making sure that the rights can be, the benefits of the rights exist and can be enjoyed. Next slide. The idea of the protection of the law is grounded in what we can call certain fundamental ground norm, and that is the idea of protection of the law, and it's based in rule of law. I chatted with you a little bit about rule of law, and therefore it is inherently values laden. Let's move along. So the next slide simply tells us that the effect of all these principles I've looked at very quickly with you, maybe too fast, I apologize if I have gone too fast. I hope at least for those of you who are not public lawyers, you've been able to get the gist of it. The effect of these principles is to place on judges a constitutional imperative to act. I'm underlining that because as we go along deeper, we're going to see where that plays out. So that I'm trying to suggest that there is a constitutional imperative. Judges just can't sit on their hands and say, well, not for me, that's for the legislature. I am suggesting that even if their intervention is to say to the legislature, review, revisit, reconsider, what they cannot do as guardians is sit on their hands and do nothing. Next slide. All right, so let's take the shift to where we really want to get to. We're just about on my clock coming to about midway to where we want to be, and so I think we can make good time as we progress. Public law. Again, this is just some background theory. I know that part of this session is for Suzanne's class, and so we're just doing some bread and butter theory for those who are there, but maybe it's helpful for everybody. Public law really describes, in the classical sense, the structural arrangements that inform the distribution of power between state agencies. As you know, the three arms of state are obvious, but also, for example, if you have institutions such as an ombudsman, a DPP, and so on. So structural arrangements, institutional arrangements, how the state is structured. In that we discover something which is part of what I call the invisible, not me, Lawrence Tribe calls the invisible constitution. That is, for example, separation of powers principle. So the relationships, I'm going to underline that word, relationships. Private law describes, however, relationships between and among private entities. So public law is relationships now between the state and the citizenry, the state and private persons, the state and state agencies, but private law is between relationships between private entities. Fundamental freedoms, Lord Diplock in Thornhill, he tells us, Thornhill is one of the early cases, 1974, right? In Caribbean constitutionalism. What he tells us is, you know, these fundamental rights that these constitutions have all written about. Well, you know, they were in existence prior to the coming into force of these constitutions. Why do I peg that? I peg that because sometimes I think we think the constitutional rights are constituted by the Constitution. Well, they are, in a sense. But what Lord Diplock is helping us understand, I think, is that the timeline does not start at the point of promulgation of the Constitution. These rights are rights that pre-existed, that were always enjoyed under the common law. And I'm going to invite us to hold that, because that can become a place from which we can develop this intersection that we are exploring. So just keep in mind, Lord Diplock is saying these values, let's think about them as values, have pre-existed constitution and were actually part of the common law. Now, take, for example, something like property. Well, let's take an easier example, maybe defamation. Right to reputation. In public law, it arises in a certain way, but in private law, it does too, in the law of defamation. Property law. You have a right, a fundamental right not to be deprived of your property without due process. So it's a fundamental constitutional right. But in private law, it's manifesting. The same value is manifesting in trespass, in the inviolability of ownership of property. At the heart of these two spheres that we have, I think, a little bit disingenuously separated out and drawn this bright line between, where the twain shall not meet. Indeed, I think what Lord Diplock invites us to ask is, but hold on, are not the values common and to be found if we have eyes to look and see in both realms? Yeah, so let's move along. Well, we've covered this. People's ultimate law, Constitution embodies core principles that we have affirmed and agreed to be governed by. We can move past that quickly. Next slide, please. It is the courts as guardians to uphold it. We've covered that. We can move along. The idea that constitutional values trump all other legal values. We had a question on that earlier, so I'm not going to dwell on this too much, because I think we got a sense of what the group feels about this. Should constitutional fundamental rights be directed to state agencies only, or also to private entities? In a way, we've interrogated that a little bit collectively in our Mentimeter question. And so I want us to start thinking about this idea. Can we speak of the privatization of human rights? Is that something, is that a construct that we can start thinking about? Let's move along. What we want to start doing now is entering the heart of this conversation. It's a conversation about something called horizontalization and constitutionalization of private law. So typical of lawyers, we come up with these make up these words that we don't even understand them, and we expect other people to understand them. So I'm going to just try and deconstruct this in plain English, as simply as we can, so that we demystify it. The image there shows what happens when you look at the erosion of the landscape. And what you discover is that even as a landscape has a vertical profile, the strata of a landscape is horizontal. There is horizontalization of the landscape. And you see that in your image with the substrata. And in a sense, that's an image I want you to think about to understand this. We're talking about the horizontal effects of fundamental rights. So the vertical is from the state in a hierarchical model of a pyramid, coming down and going back up between state and citizen. The idea of horizontality is to conjure up an enlarging of constitutional effects, that's important, into the law and society beyond this vertical, rather limited sphere. And so just use the image of the landscape that I've put up there for us to just think about, and just allow that to settle in you. And I think you get a very, very good grasp of what we're trying to talk about. This horizontal effect we're going to talk about, you're going to hear me talking about it a little bit more, is nothing more than an enlarging of the constitution, of the effects of constitutionalism into private law and society. And that's what we're talking about. Next slide. When we talk about rights, what do we mean? All this rights talk. And I think that this is Judd Matthews I'm using insights from. And I think it's so useful because what we're invited to do is to think about rights as legal relations. And once we shift to this idea of relationality, I think it becomes easy to sort of get a handle on what are the issues. The consequence of my right against you, I have a right against you, we look at 3 examples momentarily, has equivalence in your duty towards me. So if I have a right against you, you have a duty towards me. And so what they talk about is a claim right is correlative to a duty. If I have a claim against you and a right against you, that has to be correlated to a duty. Well, 3 easy examples. If I have a right that you stay off my property, you have a duty to stay off my property. If I have a right to my good reputation, defamation, you have a duty not to impugn it. If I have a right not to be enslaved and to freely contract my labor and services, then you have a duty not to use me for forced labor or to exploit me in forms of domestic or commercial servitude. So that's the claim right correlative to duty. And that's the way that I'm inviting us to think about rights as legal relations. And right away, I am hoping if we frame it this way, you can begin to see how the concept of correlative rights and duties can apply in all legal relations. Whether they're based in public law or private law, it matters not. Let's move along. Why then should we even have this conversation about the horizontal effects of fundamental rights? 2 reasons. What we can call a normative justification. That is to say, and we've covered this ground, if these values are normative for our society, and overwhelmingly we agree that they were, well, then there is a good reason why they should have horizontal effect, because they are normative for the entire society. But secondly, and more pragmatically, there's a protective purpose. Protective meaning, what are we going to do if there are infringement of these values happening in certain spheres in the society? No society is outside the law. To speak about the rule of law is also to talk about a society, we say, of men governed by laws. Of course, that is totally gender apolitical, of people governed by laws. So can you have some segments of a society of laws outside of the fundamental laws? That is what we're talking about today. So the second answer to why we should be talking about horizontal rights is what I am describing as the protective purpose. You know, you're going to start thinking about the right of choice. I'm going to come to a Jamaican case of Tomlinson. We don't have time to look at another one of Bain and about the choice and competition of choices in rights. But for now, let's just stay with the idea that the answer to why is because there's a normative justification and a protective purpose. As we move along to our next slide, we want to talk about, I just spoke about why, when should an intervention take place? Well, in a way, the answer is self-evident, I hope by now, when there's a normative gap. Why is, we said, one of the answers to why was to establish consistency with norms, to have normative consistency. And so therefore you would intervene when there's a normative gap in the private or public spheres of the law between these values. A gap between normative constitutional values and standards and existing societal laws or practices or behaviors, which is the question that Douglas was asking in a sense. Well, should the state be intervening legislatively? Yes, maybe. Who can move and leverage that? But for now, when should we intervene? When there's a gap. And the gap is the gap between the values and standards and what exists. Let's move along. When does a normative gap exist? It exists when there's a substantial demand for the protection of an interest that is not being covered by the ordinary law. The easy example, of course, is anti-discrimination statutes, for example, that fail to ban discrimination on the basis of sexual orientation, when equality rights are clearly identified that that is not meeting our constitutional standards. So wherever there's a protection and there's a deficit, even if this deficit is in the statute, then an intervention becomes maybe expected by society and maybe to be acted on, even if first by the legislature, which begs the question, what are the rules of private corporations, the courts, and or private citizens? The next slide. Just tidying up this, we talk about, what I like to talk about is the idea of the invisible constitution. And basically to say that, you know, some of these values are invisible. I say that because sometimes we will read in the Constitution and not necessarily see anything prescriptive about the rule of law, but it may be very fundamental to how we have agreed to govern ourselves. And so I think it is important that we at least touch on it and say that sometimes we have to look for what we can call the invisible constitutional values, the values that are there that we have agreed to, that we need to think about. Let's shift a little further to become even more practical. Horizontal effects. How can we think about them? You can have direct effects and indirect effects. Direct effects obviously exist, as you may see in the slide, in two ways. Vertical, we spoke about this, when an individual can invoke a provision against the state. Classic case. Individual can come to the state and say, you, the state, have breached my right to something, protection of the law, non-discrimination, or whatever. You can also have a direct effect if an individual can move directly against another individual for a breach of a fundamental right. You're going to see an example of that in Jamaica in a 2011 provision in their Charter of Rights and Freedoms. But direct is when you can move directly against the state or directly against a citizen for a remedy for a breach of the fundamental rights. But you can also have an indirect effect. It is indirect when it is mediated through the state. In other words, rights obligate public authorities to regulate private party relations in ways that constrain their freedom to do whatever they want. And so you are, as between relationships between private individuals, you are imposing these values and regulating the behavior. So the little graphic shows us the case of a judicial officer making a decision that is affecting the relationship between two parties. And so that is an indirect horizontal effect. So two kinds, direct effects and indirect effects. Next slide. Direct impact, let's go a little deeper. This is a little bit, again, of the theory, going a little bit deeper. There are two ways that I'm going to suggest to you. Let's start with B first, because it's much more straightforward. Statutory warrant. In 2011, the Jamaica Charter of Fundamental Rights and Freedoms mandates direct horizontality. Basically, it's section 13.5 says that these rights can be enforced between citizen and citizen. So Chief Justice Sykes, here's what he says in the case of Tomlinson. Now, with the promulgation of section 13.5 of the Charter, a citizen may enforce rights guaranteed under the Charter against another private individual, which includes companies. So in Jamaica, by section 13.5 of their Charter of Fundamental Rights and Freedoms, the power is given and the jurisdiction is conferred for one citizen, a private citizen, to bring an action against another in relation to fundamental rights. So that is a very easy example of how interventions may be possible through the intervention of the legislature, in this case, the Constitution in Jamaica. But in the Caribbean, we have modification clauses, which are part of the acts that bring constitutions into being. And they relate to existing law. Now, by existing law, we are talking about laws that were in existence at the time of or before the promulgation of the constitutional instrument. So for the moment, just draw a little bit of a line between what happens at that time and before and what may happen after. So for the moment, we're not talking about statutes that were passed post-constitution, new statutes. For things that happened before, legislation that existed before, the act promulgating a constitution says, and this has been upheld by the CCJ, for example, in Nerve, it's called the modification first principle, says that existing laws can be modified where that is possible to bring them in line with fundamental principles. This really comes out of the supremacy principle that I shared with you earlier, because the Constitution is supreme. And so you are taking pre-existing law or existing law, as this is called, and you can reinterpret it in ways that align. And so that is another way in which you can have direct legal horizontal effects. Let's move along. You can have indirect legal effects, as I explained, by the intervention of state agencies. Now, in this, as an example, I want to use a case on the CCJ. It's the case of Sandy Lane Hotel and some private parties, some workers. It's a 2022 decision. Several workers, 5 came to court, were dismissed. They came challenging the dismissals as unfair dismissals. And what the CCJ does is something very, very interesting, because under the strict terms of the contractual arrangements, it was arguable that the employer followed the procedure for dismissal. But the CCJ talks about and actually develops the common law as a way in which the rights between parties can be mediated according to these core values. Writing for the court, the president of the court and President Saunders and Justice Rajnath Lee say, the genius of the common law, however, is that when judges perceive gaps in the common law, they are empowered to fill them. As I explained to you, the case was about employment contracts and unfair dismissal. And here's what the court says. In the Sandy Lane case, they looked at the history, we looked at the history, and we say, given especially the sordid history of master and servant relationships in the Caribbean, our court must fill this gap in the common law. The common law equivalent to the civilian principle of good faith is to imply into every contract of employment a term of mutual trust and confidence. And that is what the court did. And so the court found, as a question of law, that in order to have this employment relationship aligned with core values, which are governance values, this principle of mutual trust and confidence, which is a good faith principle that the court speaks about, is implied into every employment contract where it is not already in written form. And on that basis says that from a governance point of view, if you are going to be in the government, remember I said governance is about how one party's actions impact or influence another party's actions. And so when an employer is terminating an employee, that is one person's actions having an effect on another person. And so what the CCJ is saying is the common law can be developed in 2022 by implying in every employment contract this common law principle of mutual trust and confidence. And in this case found that there was a breach of that in the behavior of the employer, and so found for the workers, found that they were unfairly dismissed, and then of course grant certain redress. So indirect legal horizontality is when, for example, the courts mediate indirectly by interposing between two private citizens certain core values. And Sandy Lane is an example of that. Let's move to the next slide. Well, as I've said, indirect also is in remedial interventions. We're going to come to a case later that we'll look at that. So I'm not going to spend too much time now about it, but only to say courts are an arm of the state. Courts therefore have a constitutional duty and responsibility to apply these core principles in not only its administrative functions, but also in its core judicial functions, hearing and disposition of matters, and must do so, I am suggesting, both procedurally, remedially, in the remedies it grants and the orders it makes, and that these ought to be aligned with fundamental rights and freedoms. So this is another indirect example of how these values can get applied through what I call remedial horizontality, as I've just explained. So let's move along. I'm not going to spend too much time on this because we need to cover some ground. This is just trying to help us understand that in this relationship between private and public law, there are two frames. One is the subordination of private law to fundamental rights, where fundamental rights trump the private law. The other, which is my own personal preference, is a more complementary approach, which says although fundamental rights enjoy a higher position in the hierarchy of norms, they are fundamental. Private law does not lose its ability to regulate the relationships between private parties according to its own logic, and thus preserves its autonomy. And so it is in the common law realm, incremental introduction of values, and in statutory context, reading statutes where there may be more than one meaning to align with core values, and on a case-by-case basis, as in the Sandy Lane case, finding how we can achieve complementarity between fundamental rights and private law. That's my own sort of inclination, but you will have to make up your mind. So quickly now, I want to look at 4 cases. I'm going to cover this ground, as I say, quickly. This early case in 85, we spoke about it already. This is Rambuchan and Trinidad and Tobago Television. Trinidad and Tobago Television is a private corporation set up as a private company. Rambuchan is a politician. He's in Trinidad and Tobago. Trinidad and Tobago Television has a monopoly on television in Trinidad at the time, and he wants his political message covered. It's refused. He comes to the court and he says, well, hold on, this is, you know, breach of my right to freedom of expression, equality of treatment, and so on and so on. The state argues, you have no locus, and this is not a matter for constitutional rights. Why? Because TGT is a private company. They apply the personality test, meaning you look at the legal personality of the entity, in this case, Trinidad and Tobago Television. It's a private company. It's incorporated under private law. It's not a state agency. So stay out of there. Public law, fundamental rights, redress do not apply. That was the neat approach that prevailed for a long, long time. Justice Dayal Singh would have none of it. He says, hold on, we need to look at the nature of what's going on at TGT. We need to look at its function. We need to look at social context. We need to look at all these factors. In fact, he says, look, he uses the Latin phrase fiat justia ruat caelum. Let justice be done, even if the heavens have to fall. And he identifies that TTT is in fact performing a public function. Next slide. And because it is performing a public function, then it is subject to these constitutional principles. Now, of course, he makes it a public body for the purposes of constitutional law. So he deems it a public authority, and so the principles apply. So we're still in the vertical application, but notice a shift, because even though it is a private corporation, because of the duties, its functions, its nature, and social context, it is deemed a public authority, a public agency, and so subject to these fundamental rights. Next slide. Antigua Times is sort of the converse. In Antigua Times, the question is whether a corporate entity can enjoy fundamental rights and claim that they are breached. And the Privy Council, this is in 75, even before Rambachan, says absolutely. Maybe not all rights, maybe not the right to life, they, for example, say in the judgment, but you know, when it comes to certain other rights, for example, relating to property and freedom of expression, yes. So here we see now that on one hand, a private corporation can be deemed a public authority for the purposes of these fundamental rights, and a private corporation can have fundamental rights in relation to infringements, of course, in Antigua Times by the state. So for those of you who are private lawyers, for those of you in the corporate class, and you're wondering, well, okay, you know, how is this relevant to me? Is this really for a constitutional group of people and public law? No. These two cases are telling us that, hold on, once you're in the private realm, once you're in the corporate world, this question of fundamental rights is relevant. The decision also demonstrates, I think importantly, a willingness by the Privy Council to broaden the scope of protection of fundamental rights, to search far and wide. They went to the states, they went to other Commonwealth jurisdictions for a rationalization to justify this outcome. They looked at social and economic contexts in their reasoning process. For me, I think it is trying to suggest that from very early on, from years earlier, 75 and 85, can we go to the next slide? These two decisions, Rambachan and Antigua Times, they show us how the law is evolving, how it's breaking through boundaries that prior to seemed insurmountable. They are showing that the law is in a constant state of evolution as it responds to changing socio-legal needs and demands. And I think that is important for this conversation. So let's not get stuck in always looking backwards at precedent. Let us also recognize that we have to be in the present, in the social context of this moment as lawyers, and think about the needs of today and of the future. Next slide. Todd and Price is an interesting case because this is a private law case. This is coming out of Guyana, in which It deals with transport. Land, Roman Dutch law applies, and so land, it's like the torrent system, the land registration system, but it is a Roman Dutch system. You get something called a transport. The little image gives you a little example of what it looks like. It's like a certificate of title, if you want to use an analogy. It's not, but it kind of, think of it that way. You get a transport. The key thing is your title is supposed to be inviolable, indefeasible, and good against the world in rem. In Todd has a title, a transport, but he, like so many Caribbean people, diaspora, he lives out of the region. Somebody perpetrates a fraud and fraudulently transfers his transport to someone else price. The person who is the fraudulent person is someone called Jibud. So Todd discovers this not long after, brings an action against Price and says, hold on. Well, look, you got this through fraud, but it's my title. That's not right. But cannot prove that Price was complicit in the fraud. And so the courts, including our court, said, well, you know, tough cookies. Yes, your title was indefeasible, but you know we can't do anything to help you. Well, I think our sense of justice would tell us that Todd is aggrieved. We have to ask whether justice was done. What is critical in the CCJ decision is this. We say that the courts are duty-bound to interpret and apply, the DRA is the relevant legislation for transports, the Deed Registry Act, through constitutionally declared lenses to bring it in conformity with Guyanese principles of constitutionalism. And what the court does, without overreaching, is send a very clear message, inviting the legislature and the executive to revisit this legal environment to try and do justice. Because, for example, in the RPO, that is the Real Property Ordinance, which Guyana also has, if a person loses their title, there's something called a compensation fund and they can get compensation. But in the transport system, which is similarly circumstanced, there is no such provision. So even if a state wants to hold on to the policy of land registration, and yes, if somebody gets your title, that deed is indefeasible, the opportunity to be compensated where you are an innocent person should apply in both regimes. So what does the court do? The court is trying to indirectly get the constitutional effects, the values, not in its outcome, but in a strong recommendation to the state for a legislative review and response. That is a restrained example, but notice what is at the foundation. The court's sense of duty, not to just decide the case in a strict legalistic way, but to say, to name, identify, and call out the constitutional gap. You remember we spoke about the normative gap, to call it out and to invite response by the state, trying to hold a balance between regard and respect for the legislature and the executive, but also understanding its duty, its responsibility as guardian of these principles and naming them. Next case, please. Next slide. Belize International is the last case we look at. I'm just looking at the time very quickly. And this is interesting because this is a case between a private corporation and the state of Belize, in which the private corporation was given through contract, a commercial contract, the authority to run 2 shipping registries, basically to run the port in Belize. In 2008, a new government comes into power and deciding that an extension to this facility for BISL, the private corporation, the commercial enterprise, was unlawful. In June 2013, forcefully and without any court order, enters onto the port, takes possession literally of the registries from BISL and runs them. What is fascinating in this case, and the judgment led by, written by Burgess, Justice Burgess, he explains why in a strict contractual sense, the state is at fault. But agreeing with something that Justice With and I developed says an alternative route to remedy and damages is a constitutional route. The constitutional route was simply this. There are certain principles that are fundamental. In this case, a good faith principle that is linked to the rule of law. And the state in its commercial contractual dealings with BISL breached that principle, that good faith principle. You remember we saw it in Sandy Lane in private employment contracts in which President Saunders is saying the good faith principle becomes a common law principle. Here, the CCJ is saying in this commercial relationship, the state, by breaching this good faith principle, actually, that sounds in a remedy in damages. And so 3 of the judges of the 5 agree that that is a route. In contract law, the duty of the government implies treating with contracting parties fairly, honestly, openly, in short, in good faith. This is about governance. This is about good governance. And this is about the courts in the public law realms establishing as a governance principle, the good faith principle, and as we have seen in Sandy Lane and now in BISL, applying it through different routes. In Sandy Lane through the common law, the same governance principle in both realms. What I am suggesting is, at the heart of this is a unity, a commonality around what are core values. Let's move along because I won't spend too much time on this. BISL is a hybrid situation because, as I've tried to explain, it is both the classical vertical analysis because it's like the state, but also it's indirect remedial because the courts have intervened indirectly to say there's a remedy. Jamaica, next slide. Jamaica has always prided itself on being a trendsetter. For the Jamaicans among us, I suppose you want to give yourself a little shout out. That's fine. It's true. It's true in our context. So the shout out is justified. Section 13, as we've looked at, says that, hold on, fundamental rights can have a direct effect as between legal relations between private parties, and by constitutional and legislative warrant, there is now direct horizontal application of charter rights. Next slide. The big question in Jamaica is, to what extent, how far can we go? I'm hoping in the conversation, maybe some of you read Tomlinson, because what Tomlinson and another case Bain raised for our consideration is in this balancing of rights. Tomlinson is a case in which Tomlinson says, my right to freedom of expression, you are a private corporation, a television house and other media houses, you should be carrying my public service announcement, which is all about tolerance for gay, homosexual males. The television stations say, well, hold on, we have rights too, and our rights are to determine what our programming should be. And so we were within our rights to decline, to refuse to carry what you call your public service announcement. And the courts had to resolve that competition of rights. Nobody disputed anymore that as between two entirely private citizens, Tomlinson the individual and a private corporation, in the other case, television stations, these rights could apply. In the end of the day, the courts determined that, you know what, the television stations and media houses were within their rights to decline. And so Tomlinson does not succeed. That's a question for debate and discussion. I'm using it as an example, which I think we need to talk about in this session, about how in Jamaica, you have, as I've already said, direct horizontal effects of fundamental rights through their charter. So let's move to a question, which is a Mentimeter question. I've been chatting a lot, and it's time to hear from you a little bit. The next slide, please. So while we wait on the next slide to shift, just right. Chief Justice Sykes, writing in the full court, Court of Appeal heard this matter, and so it's important. For that reason, because it's reached that tier, says, asks a question, maybe rhetorical. Could it be seriously contemplated that in Jamaica, in light of the Charter's reference to non-discrimination, and we have that everywhere in the Caribbean, that a court in this country could enforce a private law arrangement based on explicitly racial considerations? Would a court influenced by the Charter not say that any such provision is contrary to public policy? If so, would this not be indirect horizontal enforcement of the Charter? So he's posing a hypothetical, which I want to use as an entry point. Bearing in mind what I just told you about Tomlinson, where you have competing rights. Suppose, for example, a private law says, well, hold on, we have a right to decide how we run our business, who we employ. We have rights of privacy also. We have rights of autonomy also. So if we want to say only certain people can be part of our organization, that's our fundamental right. Well, Chief Justice Sykes poses the question. The question for you is, if you were a judge in your jurisdiction, how would you respond to a fact scenario such as this? And we want you to share your response, just a few words, a short sentence. It's a non-discrimination. It's in the hypothetical. We have to accept based on explicitly racial considerations. I am putting into the equation that the justification, the explanation by the private enterprise is that we have a fundamental right to decide in terms of our right to association, who we associate with. And so we can say to you, you have no right. We don't have to accommodate you in our association, in our company, in our group. And so please join the conversation in the Mentimeter. Let's hear what your thoughts are. Too provocative, Tracy?
Well, we have other questions, which I know folks have. So they may have, let's see if they have an opportunity to answer this one and have thoughts here. But I know that we have a few others.
So what I'll do is, if you want to get some answers, that's good. If not, I can close off what I'm doing and we can move on to the chat, because I'm looking at the time, and maybe we should do that. You tell me.
Yes, I think let's get to some of the questions in the chat. This may be one which people pick up again.
Okay, good.
So folks want to see the question, and maybe we could cut and paste the question also in the chat, and some may wish to take it up.
All right. So that I think then let's go back to the slides and let me finish off, and let's move to our conversations. I'll just finish up very, very quickly. If you give me 3 minutes or 4 minutes, then we can move straight into the open questions and discussion. So, right. So, I mean, what are the implications for good governance? Let's move to the next slide. Ontario and Fraser, I put that up there because in Ontario, there was actually a legislative ban on farm unions. A lot of Caribbean people go to Canada, to Ontario, to work on these farms. And they had to go to court to prosecute their right to freedom of association. And what the ILO decided similarly, the Court of Appeal decided similarly, the Supreme Court decided similarly, basically saying that it violated, this ban on unions violated the fundamental right of over 100,000 migrant and domestic agricultural workers by denying them the right of association. What I want to really place this in is a values point context. And the Canadian Supreme Court in Fraser is valuing the right to freedom of association because it concerns power relations between contracting parties. And you notice I'm trying to keep the conversation in terms of relationships. And so that private corporations, even though this is a legislative intervention and they are saying striking down the law, it is essentially about how private corporations are being permitted to treat labor. So next slide. This is Michael Foucault, who is, I think, excellent on the question of government and governance and power relations. And essentially, he is saying to govern is, which is what I shared with you earlier, how what we do affects other people, how our actions impact other people's actions. And so government is not about government in the way we think about it in terms of the arms of government, but government is about governance, because it is about power relations and relationships between people. Next slide. Yeah, I wanted to kind of close off on this idea from Professor McIntosh, who I think is so important in this area. Principle, what is a democratic constitution? It is a principal expression of a higher law. We looked at this, of a political ideal by which we agree to govern ourselves. It is all our ways of living together are subject to constitutional injunction, he says. And look at that. All our ways of living together, he is suggesting, should be subject to constitutional injunctions. The Constitution concerns the ways in which individuals mistreat each other in the society. So I've tried to bring us right back then at the end of this to where we started, you know, this idea of constitution and values. So I think from there, the next slide is a segue into our more open discussion. You know, how do we go? How far do we go? How soon do we proceed? What I suggest is that the answers to these questions will determine the kinds of societies that we will inhabit and bequeath to our successors, because we are the authors, the architects of our own destinies and futures. And so really, what are your thoughts? So with that, Tracy, I think we can move to a more open-ended conversation. Yeah.
Thanks so much, George. And I know I don't want to lose any time. So Suzanne has tracked some of the comments in the chat. And Suzanne, I'll hand over to you. And then Douglas Mendez, who is in the room, can also come on screen to ask his question. Others may have questions at this stage too.
Oh, thanks, Tracy, and thank you, George. I have my own comments and questions, but I will yield at this time to those who have posed a few of these comments, which I think perhaps you may wish to, discuss. Kalina Balkan says, but there is no disconnection from all values. The underlying core value of business is profit. So we have to actively protect human values, because business will continue regardless. I'll continue because what Tyrone Bailey says follows on that. I think whether the state has such a duty should depend on the circumstances of the case. It might depend on, example, nature of the right, what due diligence in the circumstances may reasonably entail. And so I just wondered if you wanted to address those, George.
Yeah, no, the comment about, you know, business is about profit. It is, yes, that is true. But I don't think that business is only about profit. I think that corporate governance now has broadened its relationship with democracy and democratic values. And I think many corporations are willing to play a role in democratic governance. And so first of all, I just want to say that I don't think it's as simple as business is about profit. I think with the greatest respect, I think that is a little unfair. No doubt businesses are concerned with profits, but I think that there is a way in which the pursuit of profit can be reconciled with values. And I think that part of what this conversation invites us into, and I mean, I'm speaking directly to those who are in your class, Suzanne, and those who are the private lawyers, is not to hold these either or divides and to start thinking about both and. How can we both make profits? Well, that's our business. We have shareholders and so no problem with that. But how can we also contribute to through values, shared values, to the development of society and the democratic process? And I think if we try to stay in that intersection, and I'm using as a model throughout this here intersections, Venn diagrams then with intersection circles, if we can find commonality in these intersecting spaces, I think there is room for responses that can accommodate both. If we have to choose, then I think that is where the balance, second comment, Suzanne, that is where the balancing comes in. I think it is case specific. I think it is context specific. I don't think there's a neat answer that I can say values trump profit. I think that the Bain case is an interesting case out of Jamaica. I don't want to go into the case. I don't think we have time. I invite you all to read it and contemplate. The university loses the case on discrimination, termination based on discriminatory grounds. But, you know, the challenge is, you know, where's the balance? In Tomlinson loses. The balance goes the other way in that, you know, so I think that balancing what is in nature, what is a duty, it's case by case, certainly, yeah.
And it's so interesting from the class point of view, the corporate governance class, where we have explored stakeholder theory and that has taken hold. And we accept that, in fact, the values, all the protections, human rights, whatever, are all intertwined with profit. I mean,
Correct.
no longer do we speak about them as a mutually exclusive goal.
Exactly. Yeah, absolutely.
Tracy or Douglas, there was
could we take Douglas Mendez? He may not be able to come on video, but I think audio is possible. Douglas?
Hi, Tracy. Yes, I'm seeing myself. I don't know if you're seeing me now. Peter, this is very interesting. And obviously, in a case like in Jamaica, where the Constitution specifically provides for horizontal effect of constitutional rights, then, well, that's that. I suppose you're more concerned with a situation where the Constitution applies only to the state, or the relationship between the state and citizens. The example that you gave of the implied duty of trust and confidence in an employment contract, that certainly has been an area where a lot of values have been poured into the employment contract. So that the one you spoke of earlier on, but it has also been used to deal with situations where an employer is paying a woman less than a man for the same work. And
in that case, the equality provision is the value of equality is
the value of equality, yes.
Influencing, yes.
Yes, and in some instances, and you can see that it could be broader. It could be any form of discrimination that having no relevance to the job that is being performed. You can see a court developing the principle that, or developing an implied, or saying that there has been a breach of the mutual trust and confidence duty. Of course, you'll have to work through the various other ways in which that, these values can be applied. But what I'm wondering is whether we are necessarily applying the constitutional rights that you find in the Constitution, or we are simply applying values that we have now come to accept to be part of our constitutional values. Let me give you an example. We do have constitutions where the anti-discrimination clauses do not have sex as a basis of discrimination. And let us assume that it is a country where the Privy Council's ruling that the preambular clause is not justiciable by itself, and therefore you are stuck with the limited grounds of discrimination stated in the discrimination clause. If in such a country you are faced with the question whether the duty of mutual trust and confidence is infringed by paying a woman less than a man, it seems to me that the court will go ahead and say, will apply a broad equality value,
exactly,
rather than being hemmed in by the restricted provision in the Constitution.
Well, and so that the example is maybe, it gives us too easy an out, right, Douglas? Because we have the equality provision. So in a sense, we don't need the absence of sex as a discriminating factor because we have the equality provision, right? So yes, the value that will be applied there, I agree with you, would be the equality provision, and that's how we get through that. I'm just trying to be clear as to what you are asking. I agree with you that in that scenario, the equality provision gets us to equality of treatment. It circumvents the challenge you faced where you don't have a preambular value and you have certain categories of discrimination, in this example, that do not include sex as a discriminating consideration.
Yeah. What I'm getting at is that in the common, to the extent that you're applying the common law, and that is what you're doing when you're trying to figure out exactly what this implied duty of mutual trust and confidence is. When you're applying the common law, then you're applying broad values, which are not necessarily to be found in the Constitution. When you there may be some cases where when you are trying to determine what the common law is, where the common law is trying to balance rights, like in defamation, for example, where you have a clash of rights, the freedom of expression versus the right to reputation, and you would have to decide whether the way it is balanced at common law accords with the Constitution, because the law itself has to accord with the Constitution. So in that private sphere, suppose the defamation law is being used to regulate the relationship between private individuals. So in that sphere, you will be applying constitutional values because the law has to comply with the constitutional standards. I'm just trying to figure out in what particular scenario you will find yourself saying, I am applying a provision under the Constitution. You're using the example of slavery and forced labor, for example, but we already have forced imprisonment.
Yeah.
If somebody, I'm not too sure exactly how you would deal with a contract in which somebody is being paid substandard wages, and I imagine it will come before the courts as enforcement. But I don't know, maybe it's the employee might say, I have been constructively dismissed because I'm being paid substandard wages. I'm just trying to figure out the ways in which that would come before the court, for the court to apply the constitutional standard of the prohibition against forced labor.
Yeah, and no, so maybe, Douglas, the way I can respond to this, just to keep it within the framework of, I think, the class, is that when it comes to, say, legislation, if there is an interpretation, and if there is a range of interpretations and applications, the one that should be chosen should be the one that most aligns with constitutional values when we come to legislation. So that's one way in which the values are being applied through statutes. So wherever there is a statute and you have a choice to make in terms of interpretation and application, I'm going a little further. I'm saying courts as state agencies in their remedy and process are duty bound to fulfill these values, right? You have to at least align with the values. I would think that that should be uncontroversial and easy to accept for everybody. So that for the private lawyer, because you're in the private realm, even if governed by statute, you're not somehow outside of the world of constitutional values, because when you have to advise your clients or defend or prosecute, as the case may be, a case, you need to also be thinking in a legislative framework about this question. Well, how is this law to be read and interpreted, viewed through the lenses of relevant constitutional values? So that's one way I would say it's relevant for the class and the question. Second way is this, again, for the private lawyer and corporate lawyer in the private law realm. Some issue arises. It may not be governed entirely by statute. Common law principles may apply. A question is, how can the common law be applied, developed, nuanced, in order to bring the development of the common law in alignment with these common values, these core values, and how does that impact people's rights and remedies? So through the root of the common law, the values can actually influence development of the law. What judge-made law, right? They can actually develop it in that sense. And we can have something like the trust and confidence implied clause, which when you read the judgment in Sandy Lane, it actually, the paragraph 67 actually says, well, in civil law jurisdictions, the good faith principle is read in. We don't have that principle here, but we are actually going to bring in the good faith principle, but we're going to name it trust and confidence principle. Doesn't make a difference. A ruse by any other name is still a ruse. The point is, the court has now said in the development of the common law, as a principle, this is a principle of law. I don't think that is an example, but it is not exhaustive. So that in answer to your question and to the class, I would say that as a lawyer, you have to also be thinking not just about the past and what the law was, but what should the law be in this context, given these constitutional values which influence either its interpretation, statutes, or its development, common law. I take your point with a slavery case. Can a private citizen bring a direct case against another person, private person, for breach of the prohibition against slavery? Well, I think the answer to that is probably no outside of Jamaica. But your question before is, can a private citizen come to the state and say to the state, you have failed to intervene or regulate? So there's a case of Kariu from the Eastern African Community Court, in which a young woman was held married by deed in a practice called wahia, and literally got a deed of emancipation, comes to the court and says that, look, I was a victim, sues the state of Niger, saying I was a victim of slavery. And the state of Niger, it goes to the community court, and the state of Niger's defense is you were lawfully married, had a deed, and nothing unlawful. The community court says to the state of Niger, you failed in your duty as a state, and ordered compensation. I forget how much it was. It may have been 20,000 US or whatever, but ordered the state of Niger to pay Miss Kariu compensation for the state's non-action in protecting her rights. So I thought that was a question very earlier on in this engagement that you were moving towards, because Cario is an example of that, albeit in an African context and with a community court, fair enough, but it is an intervention where a private citizen who, for example, is the victim, survivor of human trafficking, etc., can sue, for example, a state and say, you, the state, failed. And that is the Maya Alliance principle, that you, the duty of a state in relation to certain constitutional values is to take steps to ensure that they are protected, right? That opens the door for a private citizen to sue the state to say, I want compensation for you for what happened to me, albeit at the hands of another private individual, which is Cario. I'm speaking theoretically and relying on the case. I don't know if that helps you in your question. I don't know if it helps others, but that's the best response I can give at this point. Those three possibilities as range of options in relation to what you asked. So I don't know if that is of assistance.
Well, thank you so much, Judge. Suzanne, we have a few more questions before we go. We want to wrap up on the hour. But I'm going to hand over to you.
Okay, thank you, Tracy. You know, there's a very interesting question coming from Justice Minot Phillips. As I've noticed a similar question on the YouTube, and then I had a similar question myself. So if I could just read it, and I don't know if
she could come on.
Oh, here she is, but I can read it out. What of freedom to and certainty of contract? Is this at its core an argument that anything found to be unconstitutional is contrary to public policy, and that private contractual arrangements with such content are invalid for illegality? And I know that Justice welcome, Justice Minot Phillips, can speak for herself. I don't know if you wanted to clarify the question and then have.
Thanks, Suzanne. I hope the question is clear. I mean, does it need clarity? I was just wondering if is this some kind of, anytime you get into the area where it's causing me to question whether there's certainty of contract or certainty of or an ability to contract freely, I get nervous. So I just want to know what's the impact.
Yeah, no, it's a very good question. You know, I think that the Sandy Lane case is maybe a way in which I can respond. And I mean, of course, some of these questions are not questions for which there are, yes, no answers or easy answers, right? But the Sandy Lane case is a case in which there was actually a collective bargaining agreement struck between employer and employee. So this is a big Barbados institution, Sandy Lane, and had unionized workers and so on and so on, and had a contract, right? Freedom of contract and bargaining power. Well, on one hand, you have institution and of some power, obviously, but on the other hand, you have a collective. And the court looked at and so for dismissal on the facts, the contract had appended to it a procedure, written procedure to follow for dismissal. And Sandy Lane followed the procedure, actually, or tried to follow the procedure. So that's your freedom of contract between, let's say, parties who are not maybe of absolute equal bargaining power, but and what this ECJ does is looks at the written document and says that on the facts, there were some shortcomings, but also says that the document did not include this term that where there would be a dismissal, there will be certain treatment, the trust and confidence principle, the good faith principle. and that Sandy Lane, even as it purported to follow the letter of the law, did not meet this value standard of the trust and confidence implied term, and so was at fault. Now, I offer the example, not that you should agree with it at all. It may provoke more angst for you, given your question and your concerns, but I offer it for this purpose. I think in working out how we negotiate these questions, it really is on a case-by-case basis. And I also think that we have to be careful to create absolutes. That is to say that freedom of contract is so sacrosanct and absolute that it cannot be subject to the scrutiny of values. I think that was the comment of the first person, Ms. Bulkan, who spoke about the question of profit. At the same time, I think that we cannot do the same for values. Say a value is so sacrosanct that in people bargaining, that they may not, for good reasons, choose to not water down, but to limit certain value-based rights or entitlements. And so it's on a case-by-case basis that we have to negotiate these competing principles in law. For me, I find that the law is often contradictory. And often in law, there are legal values and principles that intersect in their conflict or collision. And that is exactly where courts have to, are called upon to try and find a way forward. So it's not a clear answer to you, but it's the best answer I think I can give at this time.
No, that's fine. In the Sunderland case, though, was the constitutional issue there from the get-go, or was it something that the court imposed in the proceedings?
The court raised it. The court raised it on the facts, yeah. The gap was there, yeah. Raised it with the lawyers, gave them an opportunity to respond, etc. And why? Because if the Constitution at least governs all state agencies, then a question for judicial officers is whether as a state agency, as an arm of state, no different from the executive legislature, the judiciary is also to be governed by these values. And a question arises whether in the doing of the work that we do, we have to be cognizant of these values, as I shared a little earlier, both in the procedural work, both in our relief and orders, to try and align our work as a state agency, as an arm of state, align our work with these values. So yeah.
Thank you.
Thank you so much. Thank you, Judge, for all of the insight. It's been very, very, very insightful, and we have a number of other questions, but just have run out of time. We need a part 2, and I'm hoping you'll commit to a part 2 of this discussion, because you know, as I look at the questions, and I have my own questions and comments, it is just ripe for a continuation. So thank you so much again. And I know there's some public service announcements that have to be made. I think they are in the chat.
And we also have a little Mentimeter for some feedback, if you remember.
Right.
Yeah.
So we could close out with that. If you don't mind, George.
No, I'm fine. I'm fine. This is your class. I'm here in service of your class at your invitation, which, by the way, there are no there's no consideration flowing. So it is pure privilege, and you are both empowered to dismiss at your pleasure. I'm at your pleasure.
So maybe, I don't know how many people are able to access the Mentimeter again at this point for us to close out. Andrew is trying. Let's see if we can do a last.
I think we wanted to get a little idea of a word cloud.
Yes.
If people
Yes.
could just share,
Yes.
you know, in a word or a phrase. It is a way of, we haven't been able to accommodate everybody's questions. We apologize for that. It's always a challenge, but you can share your thoughts for our benefit. This is always very helpful for us. I'm sure for Suzanne and Tracy and Celia. So I'm just talking to allow you an opportunity to start. Share one key takeaway from this session, just something that struck you about it, anything. You know, there's no right and wrong, there's no good or bad, just what you thought. And so I
wonder if there's a challenge in accessing the Mentimeter.
I would suggest we take it in the YouTube chat, but some are responding.
Oh, constitutionalism as governance. Would we be ceding too much power to the courts?
Yes.
All wonderful thoughts. Sure, yes, Suzanne, you can jump in and say what you wanted. You've been wanting to say something.
Say it because
yes,
it's coming at me. You know, we've already ceded it, and for my corporate governance students, I want to remind you that we've been discussing some of this. When we speak about multinationals and subsidiary and trying to find, the courts have found ingenious ways to find liability for breach of human rights in that sphere. Anyone else try and punch something in for us?
I see Jimmy in the chat saying key takeaway is that constitutional law is fluid. And I heard Justice Manor Phillips asking the question, on the private law side, that certainty is valuable.
Yes.
So how do the two mix when you have values in another sense, which are very different? One where there's instability and constant movement and change, and one where you desire predictability. I see someone saying thought-provoking, especially in relation to governance and constitutionality. Thinking about the ways in which constitutional rights may be connected and not just protect private actors as they currently do, but also bind private actors. And Suzanne, I also see a comment about gratifying that our home court of the CCJ will read constitutional principles in corporate practices. I think you might equally have many corporate lawyers who are anxious that it is. But a great set of feedback, I think, both in the chat and here. I think the last comment, incisive, getting such in-depth judicial perspective was well appreciated and enlightening. And the same for all of us, Judge. It's been wonderful to have you here today. You bring an intensity to thinking through the questions which are most important. And Suzanne always reminded me of your judgments on the private law side, even though I had been paying attention to those on the public law side. Good to be at the beginning of a conversation about the relationship between the two of them. We're indebted to you for the tremendous work in pulling this together. As Suzanne said, it could be multiple lectures. And hopefully this is the beginning of a much longer conversation. Many, many thanks to you and all of those who have joined us from all over and will also join us later in watching this at a time at their convenience.
And Tracy, just to keep good on my undertaking to you all, that I'll try and have the background paper available, maybe not this week, but within a couple of weeks, that you can share certainly Suzanne can share with her class members.
Thank you.
So that I will honor that undertaking within the next couple of weeks.
Much appreciated.
I have two closing thoughts, if you'd permit me. First is one of great regret that I have not been in person with all of you and especially not in person in Jamaica. But I want to say that being with you virtually has been an honor and a privilege. And I have learned through the preparation for this class. I want to thank all of you for that. Without you, I would not have undertaken this and learned as I have. And from what I'm seeing now coming up from your comments, I certainly want to say that I think that all of your comments that I've read on the screen are reflective, introspective, and I think very, very important questions. So keep them going, keep them in your class, and maybe most of all in your legal and professional development. I invite you to orient yourself around the asking of questions. I think it's a good practice. So thank you all very, very much, Tracy, Suzanne, Celia, Andrew, Ishmael, everyone. Thank you very, very much for the opportunity.
Thank you, everyone.
Thank you. Thank you, Judge.
Thank you.